We have Miss Bliss, we have Miss Powers. And it appears that I have two matters, and I do have Miss Bliss and Miss Powers present. So council, and do we have let's see.
The court investigator had filed a motion to be released from the case and was released from the case. And so I cited this on to get a GAL appointed.
Okay, all right.
I sent an order over to the court with some blanks in case the court can enter the order. I'd sent that over before I'd gotten Miss Bliss's notice of appearance, so I just emailed it to her. I apologize I hadn't sent that sooner.
Be just a second here. Let me find my file.
I would ask that we do schedule a pretty quick. I know that there was some issues historically with getting a different GAL appointed in this matter for the timing issues. Obviously, the safety concerns and the concerns which initially brought forth the court investigator still remain. So I am asking for at least a relatively quick interim so we can get some sort of feedback from the GAL, but I have no objection to a GAL being appointed.
All right, so if we could get the next three names.
Heather Call, Ann Heights, and Keith Lawrence.
Miss Powers.
I'll strike Heather Call.
I'm fine with Ann Height.
Okay. All right, so I will go ahead and appoint Ann Height. What I don't recall is what you were proposing as far as the pay.
I had not made a proposal in terms of pay. I think that my client's income is such that probably he'd be responsible for a portion, although he's had a lot of different attorney fees with the multiple cases that have arisen. If the court's willing, I'd appreciate if they do public pay and review the finances later, if possible.
Miss Bliss.
And remember, that would be my request. I'm just recently onto this case while we've been chatting. I've been trying to look at my file to see what my client has for employment. I don't have a lot of information, at least at this point in litigation. So I would just ask if Your Honor is inclined to just do county pay, and then we can review it maybe at that interim review.
Okay. All right, based on that, I'll go ahead and make it county pay 100% at this time, with the understanding that that may change once there's more information. Ms. Bliss, are you okay to put approved via Zoom?
Yes, Judge.
All right, so I've gone ahead and signed off on the order. The problem that I have with shortening the time, it's already a pretty short time. I don't have any of the dates in this order, so that's a problem as well. So let's go ahead and put some dates in. So 30-day review with parties compliance. So we're on July 2nd. So I'm going to go ahead and set that to August 6th.
Okay.
An interim. What were you thinking, Ms. Powers or Ms. Bliss, as far as that part of it? And Ms. Height, you're on here, so you want to weigh in as well?
Thank you, Your Honor. I think I can work with whatever the other parties come up with, Your Honor.
Okay.
I was thinking maybe a month and a half out.
So we could go to, say, August 27.
Okay.
Okay, so I'll put that one on August 27, 24 at 9 a.m. And then the final, we could set to November 5th, or do you want it earlier?
I think that'll be fine since we'll have the interim.
I would agree.
Okay. I'll go ahead and set that to November 5th at 9 a.m. All right, so I've gone ahead and filled in those dates and the pay, and I believe, and the name. And so that should take care of the order. Signed off on that order. Anything further, counsel?
Nothing.
No.
All right, that's it for that matter.
Thank you.
Thank you.
Matter. This is on for a couple of things. One is a presentation of order. The other is a guardian ad litem fee waiver. And so I'm first going to go with the presentation. We do have Mr. Zandy. We do have Mr. Boaglio.
Here, Your Honor.
Okay, I'm going to make, hold on just a minute. I want to tell folks that we start at 9 o'clock. I would appreciate if you would log in at least 5 to 10 minutes early. I keep having to watch and see who is logging in and admitting them. So I would appreciate people if they would keep in mind this docket starts at 9 a.m. That way I'm not having to split my focus between listening to people and seeing whether or not somebody needs to be admitted. So I would appreciate that. Thank you. Okay, counsel, go ahead.
Yeah, Judge, I think that's accurate. This was a case that was several weeks ago, entering the proposed orders. I think the orders that I've presented comply with that. I will say that the parties have communicated to some extent and asked for some changes to be made to those. We've largely stipulated, I think. Now, we did give you a revised proposed parenting plan on June 25th. I think that's what we're working off for purposes of today. I didn't see any objections filed from Mr. Boaglio, although he has been in communication with my office requesting certain changes, which I think we've largely incorporated, which is a small step, but at least a positive step between these parties. So I don't know if there's anything else on the parenting plan itself. I would make reference to the GAL order and state that my notes are not clear. I understood that Karen Lawrence was appointed as the GAL. But the order that we've presented has Keith Lawrence as the GAL. So I'm fine either way. I don't know if Mr. Boaglio has any preferences, but if it is Karen Lawrence, then the order needs to accurately reflect that.
All right, let me just double check here.
My understanding was Karen as well.
That's my recollection, but let me, yeah, it was Karen Lawrence.
Okay, so if the court could just strike paragraph 3, line 22 on the first page and put Karen as opposed to Keith, I think that resolves that issue. And I do have some objections, Your Honor, whenever you're ready.
Mr. Boaglio, I would just remind you that you need to put objections in writing prior and file those because it takes a lot of time to go through these matters on the docket. So I would remind you of that.
Yes, Your Honor. I definitely would have done that. I just got back into town last night, and I just got the paperwork he's referring to in the mail last night. So there were just some concerns of that, some last minute changes that actually weren't discussed. I thought we were in agreement, and then some changes were made that I was unaware of.
Okay, so I changed it to Karen Lawrence on paragraph 3. Anything else on that matter? Any further objections on that order?
Paragraph 3 for the GAL?
Correct.
No.
Okay, signing off on that order. Are you okay to put a proof via Zoom on that?
Yes.
Okay, I've signed that order. And then in regard to the parenting plan, what is the issue?
It would be the holiday language and the transportation arrangements had been changed. Ms. Boaglio and I, she recommended I speak to Mr. Zandy.
Mr. Boaglio, what specifically in the order in regard to holidays are you having an issue with?
Just everything was kind of flipped on its head from what we've always done. And I was just requesting that we keep holiday language the same. All the times have been changed. All the dates have been changed. And it just is going to create a lot of chaos. And I would just request that we
have to change
well, I could go through them all, I suppose, but just everything has been changed from the original parenting plan that we've been following since May of 2000. Here's kind of my what I think we should do. 4th of July is here now. After that, we've got a GAL that's coming in. Court didn't specifically state anything for the holidays. One of two approaches to this. Number one, we could just reserve, considering that the major holidays are still 5 and 6 months away, respectively, and be fine with that. Alternatively, we could keep things the same as they were under the existing plan. But things have changed so drastically that I don't know what the court wants to do with that. So I think, again, I think the holiday schedule probably for purposes of today, probably best served just reserving on those issues. We'll get the GAL input on that. Hopefully IDL's in a better position in 5 or 6 months down the line, and we can either come back on a motion or get insight or input from the GAL when the time comes. But we don't really have any holidays until Thanksgiving, and that's still a ways off.
I agree with, for the most part with that. I would just ask that we, for the sake of safety and clarity, keep the original language under reserve for the GAL. I'd rather have it changed that way than be forced to come up with drastic changes as we get 5-6 months into this. So it seems like it would.
Mr. Baglio, I am not going to go through each of these and make changes today. I'm going to reserve on it because I'm not going to do it here and take a bunch of time when I have 15 cases on that I need to get through. So with that, okay. The only question I have at this time is in regard to the 4th of July. Any changes that need to occur in regard to that?
Not for the 4th of July. The other major concern was just the transportation. For some reason, we're altering that as well. And I just asked that the picking up parent, that just stay the same as it's always been. There's no reason to change that now, especially with extracurricular activities going on. They're always happening during my time, which, you know, I'm taking Adiel to her extracurricular activities, but it would cause an issue. They always end in the middle of my time. So keeping the language the same as the picking up parent would just logistically make a ton more sense to just keep it the way it's always been.
Okay, I don't know what it always has been. You said
it's right here. It says the picking up parent, the parent who is about to start parenting time with the children must arrange to have the children picked up. I'm just asking that stays the same.
Mr. Sandy?
Yeah, I really don't have a lot of input on that. Again, we're on a very temporary order. This was, again, I think one of the suggestions that was made by one of the counselors that I think makes sense, given the back and forth. I thought this was one of the things that was agreed. This is one of the things I think was tweaked from the original order that we gave you back on June 14th. We'll leave it to the court's discretion. Yet I don't necessarily think we need to die on that hill, but nonetheless, here we are. So whatever the court thinks is appropriate, we'll go with for now.
I'm not sure it necessarily makes any difference, but I'll go ahead and make the change. So what is the actual language?
The picking up parent hyphen the parent who is about to start parenting time with the children must arrange to have the children picked up. And then just age appropriate safety restraints and only by licensed and insured drivers.
I'm not going to add all of that in here. I'm just
of course. Yeah, I just wanted to be clear.
Okay. So here's what I have done is I have the picking up parent dash the parent whose starting time is starting time must arrange to have the child picked up.
Thank you.
Okay. Anything else?
Not for me, Your Honor.
Mr. Zandy, anything else?
No, I think that's good. Thank you.
All right, Mr. Braglio, are you okay to put approved via Zoom?
Yes, I am.
All right, I signed off on that order. So that brings me to the other matter of waiving the guardian item fee, which is really not what we do. We just have it paid by the county. What is it currently?
It's county pay for his half and then reserve on reimbursements pending final outcome. And that's contained already in the GAL order that you just signed. So I think we resolved that issue.
Okay. All right. Mr. Braglio, would you agree?
Thank you.
All right. So I won't be finding that order.
Yeah, I wasn't sure which paperwork to use. I tried to find the best I could there.
No, that's fine. The only thing I would have asked if I had to go forward was to have a financial statement, but I'm not sure where that even comes from, honestly. But
right, I can provide that if needed.
No worries, it's done. Okay,
thanks.
I have signed off on those matters. Anything else?
Not for me, Your Honor. Thank you.
All right,
That takes care of
this
that
is on for presentation of order. I did not receive any objections. Anything further?
Yes, Your Honor. I had previously communicated with Mr. Zandy that my client did not agree with those dates. Since I had communicated with that to him, there was an incident that occurred at an exchange. I do believe I provided the court with bench copies that provides the language that the GAL, Beth Fellows, has suggested the parties use to modify their exchanges going forward due to just the incident that happened this past week.
And Beth Fellows GAL is present as well.
Thank you, Ms. Fellows. All right, did you file your objections? Because I don't see them.
No, Your Honor.
Okay, local court rule requires that the objections be filed. I would appreciate if they would get done. So, all right, so what exactly, I don't know what the actual objections are.
It was to the dates, Your Honor. Mr. Zandy and I had gone back and forth on the dates, and they had not been agreed upon, and those dates that were not agreed upon were included in the order proposed by Mr. Zandy's office, and those dates just do not work for my client.
Mr. Zandy?
Yeah, and I don't necessarily disagree with that. It was my understanding of the hearing several weeks ago that you were expanding my client's summer residential time with the kids, that he essentially got a week in June, which he's had recently. He got a week in July, he got a week in August. So shortly after the hearing, we proposed those to Ms. Holder, which spoke with her client and came back and said essentially with and I apologize if I'm mistaken, I don't think I am, essentially those don't work with my client, pick another date. So I don't think that was the spirit of the order. I don't think that was the order. I think you basically gave Mr. Hellam the opportunity to pick his time throughout the course of June, July, and August. We did the best we could in working and accommodating the schedule in June. That time is obviously over. We attempted to do the same thing with July and August, but just by simply putting by agreement of the parties, the way that these two just simply cannot communicate with one another effectively, we're going to be stuck spinning our wheels significant time and significant frustration trying to come up with weeks. These are the weeks he's requested. I think they work. Again, my client is employed. I don't know that Ms. Hellam necessarily is right now. I think her schedule is much more flexible and free. And again, these are the weeks that my guy has proposed that we just were kind of bluntly returned and said, nope, those aren't going to work. So for this year, and again, this is a case with a pending GAL investigation, we are asking for those weeks. Again, I think that was the intent of the court, although not specific in the clerk's minutes, that my guy gets to essentially pick his weeks for the summer this year. We can certainly revisit that for odd numbered years next year on a permanent final basis, but for now, that we ask you to adopt the form of that order. As it pertains to the GAL stuff, and I would certainly agree, and I think it's largely undisputed, there was an issue at an exchange. I can tell the court, this is all new information to you. I don't think it's fair to put you in a position where you're playing referee, not knowing the facts. I think we can stipulate and agree to the recommendations made by Ms. Fellows. My suggestion would be that just gets done in an agreed order between Ms. Holder and Ms. Fellows and myself, and we enter that ex parte in a day or two. But for now, we do ask you to enter our order for the facts and the case that actually was before you a couple of weeks ago. I think it does reflect that.
So Ms. Holder, what is the issue about these dates?
Ms. Hellam has family coming into town the 1st through the 8th of July. They're currently here, and also from the 15th to the 19th of July. She would prefer dates of July 21st through the 28th and August 18th through the 25th. And I disagree with Mr. Zandy's characterization of these are the dates, take them. That's not what happened. The dates went back and forth. We agreed on the June dates, and the July dates we had not agreed on. And I said, those dates don't work. Please come back with some more dates that could potentially work. And I was working with my client to get some more dates.
So here's what I'm going to do. Mr. Zandy's client will pick the August dates. Your client will pick the July dates, and that's where we're going to leave it.
Very well. Thank you.
Thank you, Your Honor.
So you'll get me a new order?
And that matter's ready, Your Honor. I'm going to keep my video off if that's all right with the court, because I'm
That's
still
fine.
recovering.
Good morning, Your Honor.
Good morning.
Very minimal objections, Your Honor, and you should have those before you.
Again, I did not receive any written objections. I want to remind everyone that
We did submit written objections, Your Honor. We submitted them twice.
Okay, maybe I just missed them then. Thank you.
And Your Honor, we did have some back and forth, and I have no issue with anything Ms. Winkles has done here. We have, I think, 2 issues to address and
Okay.
record to them. Ms. Winkles can.
So I have Ms. Winkles' order. Is that what you've been working off of?
No, there's a few, I sent an initial order and then I sent updated proposed orders based on her comments. The most recent should be with a cover sheet dated June 27th.
And then there should be an objection, which is a redlined version of his order that was submitted the next day.
Okay, those get filed. They're not for my signature. I'm guessing that's what happened. That's what I see. If they are proposed orders, those get filed, so they're not here for me to sign. So let's go ahead and tell me what the couple of issues are, and then you'll need to get me an actual order.
Yes, Your Honor.
Sure.
On findings, instead of saying that there's reason to approve the order for the immediate restraining order, my language was that the reason to deny the request for a restraining order, but finds there's reason for modification of the orders currently in place. And that was just because Your Honor denied the restraining order, but did modify the orders.
Mr. Roberts?
I updated the findings in section 2 stating that the court finds there is reason to deny the request for a restraining order, but approve the provisions as set forth in section 8 below. So I'm not sure we're working off the same one here. The only issues, I know you've been sick, Ms. Winkles. I emailed you on Thursday, July 27th, informing you I updated all your corrections with some language changes, but not substance. And I think the only difference that we have is the timing from when my client requests the drug test to when it's done. It was 3 or 4 hours, or 30 minutes or 15 minutes before the facility opens the next morning. And the only other issue is the scope of the Talking Parents app communication and whether it has to be on the phone.
Okay, so the evaluation was already changed.
Counsel, hold on. What, Mr. Roberts, when is the last time you submitted a proposed order?
It was I signed it June 27th. I'm looking at Odyssey to see if it arrived, but it should have been at the court.
It is not here. It is not in Odyssey yet.
It looks like I see proposed order findings on July 1st. It sounds like it might have been scanned in on yesterday.
They weren't arrived or entered. Yes, we haven't scanned yet.
Okay, they haven't been scanned yet. So I don't know what you're looking at, because the last document I have is from June 21.
And that was what I was working on as well.
Well, I have an email to Ms. Winkles from July 27th that I sent staff I'd received. If the court can give direction on these two issues, I believe off docket, Ms. Winkles and I can reach an agreement, because I did incorporate her
Just
changes.
know I'm not looking at anything that you're talking about. So
I totally understand that.
Quite frankly, either the language that you're proposing is fine. So let's just leave it with Mr. Roberts' language.
Okay, and then the only other issue was the Talking Parents app. And that was, Your Honor stated that because there had been a restraining order in place in this case, but we were doing the drug testing, Your Honor stated that for emergencies and for the drug testing that they could use Talking Parents app. Mr. Roberts' language effectively forces my client to put it on her phone, Talking Parents, and to reply to any communication via Talking Parents. There should be no communication between these parties minus the emergency and the drug use. My client also uses a computer for Talking Parents due to the age of her phone. And she does respond, but it is on her computer. So we'd ask that our language that just says the party shall communicate via Talking Parents concerning the drug testing and any emergent information about the children, and leave it at that.
Mr. Roberts?
Couple of comments. First of all, there's no restraining order. There was a restraining order that expired quite a while ago. Secondly, my notes, it's not in the court minutes, but they're not comprehensive. My notes, which may be incorrect, indicate the court did order that it be on her phone. Perhaps more importantly, Ms. Ouellette reached out to my client about a
I'm going to object. This is not properly before the court.
Well, there has to be a way for these parents to communicate, and that's what Your Honor mentioned the last hearing. My language states, and it's still the same language from the initial order I sent. I had small modifications. My language states that the court mentioned, I believe, that she needs to put it on her phone. And my language states for timely and reasonable communication with either Mr. Agavino or Mr. Agavino's wife on his behalf, communication shall be limited to the information directly regarding the children's well-being, scheduling of parenting time, or request to submit to a drug test. If communication is abused in any way, the parties may return to court. I think that's consistent with the court's ruling, and I'd ask the court that adopt that language.
And Your Honor, if I misspoke about the restraining order, there was a restraining order in place. It was denied. So my apologies if I was unclear, or sorry, it was expired. My apologies if I wasn't clear. There is a finding of DV in this case. My client has no income. Talking parents is unfortunately a cost to put on your phone. Furthermore, we submitted the transcripts. Your Honor stated for 2 issues and 2 issues only, emergencies and drug use. All these collateral issues were never discussed by the court. This is all new. To ask a former DV victim, again, there was a finding of DV in this case, to have communication with Mr. Agavino that isn't anything to do. He has professionally supervised visitation only. There's no reason he needs to be getting a hold of her, minus for emergencies with the children and the drug use. If my client gets the talking parents on the computer, it's free to her. She can use her father's subscription. If she puts it on her phone, there is a cost to her. And again, she is currently, she's without income of any sort.
All right, so here's what I'm going to do. I don't know enough about talking parents other than it's an app. And if the app can be used on a computer and do the same thing, it's irrelevant whether it's via phone or whether it's via a computer. As long as they're using talking parent, then that's acceptable to the court.
I can modify, that's fine. With respect to the terms, what's the court's direction here? I can modify and send it to Ms. Winkles to sign.
Yeah, go ahead and modify it and then send it to Ms. Winkles for signature. Send it to my attention for signature.
I apologize, but we have a disagreement over the scope of the communication. Ms. Winkles wants, I believe, only limited to the emergencies and the UAs, and my language states.
Oh, I apologize. Okay. I misunderstood. So whatever they need to discuss in regard to a child, then it needs to be through talking parents. And I would not limit it to just, maybe I did at the time, but they need to be able to talk about other things as well. And as long as it's going okay and it's through talking parents, then that's acceptable.
Okay, so I will leave language as is, remove the phone language so long as she has reasonable access and response timely.
Okay.
Okay.
All right, that works. Thank you, Your Honor.
Thank you.
Thank you. And Ms. Winkles, I'll send you something this morning, okay?
Okay, sounds good.
Jackson
Thank you both.
matter.
Thank you.
All right.
Good morning, Your Honor. Tom Lee here for the respondent.
And Ms. Jackson is present here in the courtroom.
Yes.
All right, so Mr. Lee, I just received your proposed order, and I don't know if Ms. Jackson has received a copy of that.
No, haven't.
Okay.
Your Honor, just administrative goof on that. I just while we're on this docket, for the record, I realized when I sent it to court administration, I did not include Ms. Jackson because her email didn't auto-populate, but in short, I made sure to correct that. Now I understand she hasn't had time to review it, but this order is just a reflection of what occurred at the May 28th hearing and oral ruling by the court, as well as seconded by the clerk's minutes.
So here's my concern is, on one hand, Mr. Lee's order lists things, but it doesn't include things like the judgment. Did you see Ms. Jackson's proposed order?
I didn't, Your Honor.
Okay. So it's on the contempt, and it has, so that's a problem that both of you need to exchange what it is. But I'm more inclined to use Ms. Jackson's order because it has the judgments, it has the summary, it's a contempt order, which is what is necessary on the contempt matter. You can always add the other things in. So that's the only issue that I have in regard to Ms. Jackson's is I did not specifically order jail time. What I said is that you need to note it up again and put it back on a docket again. And I just wanted it understood by Mr. Jackson that if this continues, that the court is willing to consider and put him in jail if that's what it takes to get him to follow court orders.
Understandable, Your Honor. I would be satisfied then if the court just wanted to amend Ms. Jackson's proposed order, sans, of course, the jail time clause. That would be fine with me, Your Honor. I understand, it's a busy docket.
White out, mine doesn't seem to be here.
May I ask a question?
Go ahead.
What does this mean now?
So I can only give you so much information, but I'm taking, I'm whiting out under paragraph, I don't know if you have a copy of your order.
Yes.
If you look under paragraph 10, jail time, I'm whiting out where you had included that he had 30 days of jail time and marking does not apply.
Okay.
And then under going down further under paragraph 10, it says respondent begins making payments immediately on the current spousal support as well as the 300 payment per month on arrearages and the total amount of 3,300 each month payable by the first of each month. That the respondent and his 5 roommates have vacated the family home located in Woodland no later than June 21, 24. Last, the conditions listed in paragraph 13 must have been fulfilled by the time the review hearing takes place on June 25, 24, 4 days after the last day that the respondent must have vacated the home. I'm taking out this whole line about jail time again. And if he has not vacated, let's see. All right, so I think the rest of it is about the vacating. Let me just double check that there isn't anything else. I think that removes all the jail time language. Okay, I think I got all of the jail time. All right, so with that, I'll sign off on the order. Mr. Lee, are you okay to put approved via Zoom?
I am, Your Honor.
All right, so what does that mean? It means that I've signed off on your order, but I have not ordered the jail time. It is up to you as to whether or not you pursue it further or what you do. I'll leave it to you. If you want to consult with an attorney or whatever you would like to do, that's up to you.
I had also filed last week at the Clark County Court for a protection order, and it got approved, but it has for some reason not been sent over to the Cowlitz County office in Woodland. Where it says again he needs to vacate the house, everything else.
That's a Clark County matter. That's not something
Okay.
I can assist you with at all.
Okay. So what is with the moving out? Is this now? You had mentioned, on the 21st, he still has not moved out. Nothing has happened. It even got worse.
I would ask you to talk to an attorney. There's Cowlitz Wahkiakum Legal Aid. There's Northwest Justice Project. You can maybe contact one of them and find out what your rights are and what you can do. I can't give you legal advice.
So is this whole order getting put to another date again?
No, I've signed your order.
Okay.
It just found him in contempt, so you have another contempt order.
Okay. All right, Mr. Lee, is there any possibilities that you could answer any of my phone calls?
Well, I can't really provide Ms. Jackson. I will give you a call. I want to be respectful of the court's time, and the court has been very patient with us on this matter. I will call you. Just keep in mind, I can't give you legal advice because I'm appointed to represent the respondent in this matter.
And I understand, Ms. Lee, it was just I had called several times about the order that you had proposed you would be writing, and nothing had happened. I left you in the last time I saw Mr.
We're done on here.
Yeah.
Okay.
Thank you, Your Honor.
Ronitz and Bob matter.
That matter's ready, Your Honor, and we've received no reply to our new motion, and I believe the order is appropriate given all the other motions to compel.
Did you send over, and we do have Mr. Bob present, Ms. Winkles, did you send over orders for me?
Yes, Your Honor, we filed the proposed with the cover sheet and we sent over the originals for Your Honor's signature. And that was a couple of weeks ago, though. I would have been, we've had those done for a while, so they might be floating around. We can send you another one today. I can have my legal assistant send that this morning. There's been quite a lot of things that I think it's because of training, is what I've been told. Quite a lot of things haven't quite made it into Odyssey, but that they have them in the clerk's office. But I'm not sure if this might have been one of them. It was a couple of weeks ago, like I stated.
Yeah. I don't have anything. And the clerk seems to be indicating she doesn't have anything.
Okay, we'll have another copy sent over to the court and we'll file another proposed today.
Okay.
Ms. Gronitz did receive copies of that proposed as well, because they were done at the same time as the motion hearing was actually set.
Okay. So I need some clarification, Ms. Winkles. I have on number 7, it says motion hearing. Number 8 says motion hearing to exclude evidence produced beyond discovery deadline and order to show cause.
Yes. So the order to show, the order to show cause is I'm not sure where that came from, but what it was is this is our fourth compel hearing that we had. So that was the compel was just a review set over. We still received no information. The motion to exclude evidence, if Your Honor remembers at the last hearing, Your Honor stated that you were going to exclude evidence if it wasn't turned in, but because it was such a huge amount of evidence, I wanted there to be a separate motion so I could actually provide Your Honor, and this is the sheer amount of information that I submitted to the court was quite a lot. I wanted to supply that information prior to and give Ms. Gronitz the ability to obviously provide that information should she have it. It's listed out every single thing that's missing. It's like a 5-page order because of that. So those are the only 2 things. It would just be the review of the order compelling, the 4th one, and then a separate order excluding specific evidence, so that there's no question about what still had not been provided.
Okay, and I just want to double check, Ms. Gronitz.
Yes, Your Honor.
Okay, so if you have video, if you could go ahead and turn the video on, please.
I don't have video capabilities. I apologize.
Okay. All right. So with that, Ms. Gronitz, at this point, the court doesn't feel like it has any choice but to grant the request of Ms. Winkles based on the limited information. Plus, you didn't do a reply, so I can't really hear any argument either. So that's where we're at this point. Okay.
We have court in October. I'm not sure why we're coming to address this again. Ms. Winkles understands that this is being modified due to the auditors. Last time we attended courts requested I had the auditors get involved and submit a report to court that is tied to this case. And that's what's been taking place. So why is, there was a lot of information delivered to Winkles. I'm just catching up to speed on the 1,200 pages that she sent me in regards to this case and recognizing the deficiencies in my report to what she's claiming she's received. So there's a trend, I need to go through and audit my report to match her requests. But up until receiving this motion, I believed she had far more information than she reveals to court to have received, specifically the descriptions of the evidence. So those were separately described, and it looks like they need to be incorporated into the actual report. And that report also needs to get submitted to court, but I've been operating out of state, and I have to secure a courier to actually get that report submitted into the court system, which I've done, and they're available next week. So I'm not exactly sure what she's requesting on this, but I'm requesting that this entire motion be stricken, given it's completely out of compliance with the discovery protocol under the schedule that we previously set. I've been telling her exactly what's been going on in discovery, and she hits me with this 4 months early. Trial's not till October. Now, there is information that isn't going to get added to this case, and I'm going to be withdrawing or modifying the financial documents that are applied to this case. And I would like the opportunity to change those valuations without recourse, because this case has now been broken up into several smaller cases. So we're only dealing with the asset portfolio valuation difference of the parties in this case, a list of personal property and who purchased those items. I haven't received any information of purchases or payments made by defendant. I do have his financial statement. So I can go ahead and address my financial issues. My financial issues are the reason that we're in court for me. I need my financial issues addressed. I've been issued 1099s.
Your Honor, I'm going to object. This is not properly
Yeah.
before the court.
Ms. Granitz?
It is extremely
Ms.
relevant.
Granitz, stop.
This case is
Ms.
about
Granitz, stop. So first off, you didn't do a written reply, which is what's required. You didn't do it. Secondly, I don't know what you're talking about as far as the requiring an auditor's report. Maybe Ms. Winkles knows what you're talking about, but I don't. So I don't know what you're talking about there, but there are rules that need to be followed and they have not been followed. So whether or not your trial isn't until October is, if you haven't followed the discovery rules, which is what we're here for, then that's on you. So with that, Ms. Winkles, anything?
Just briefly, I'm not sure what this auditor's thing is. That was never required by the court. I actually submitted everything she submitted to us. I did that. That's why I renoted this just in case this argument was going to come up, to show that the deficiencies are there. I've written out the deficiencies. I've been very, very clear. I listed them in numbered format on the motion and the order. So Ms. Granitz would have time in that 21 days to respond and give me them. She did not do that. So I'd ask that the order be entered today.
Okay. So the court has seen this case over and over again, and the failure of Ms. Granitz to provide what is required, not to create. Discovery is not about creating records. It's about providing the records that you have. And that doesn't seem to be understood. So with that, Ms. Winkles, I will sign off on your order.
And we'll have that submitted to your honor this afternoon. Thank you.
This matter's done for today. Mr. Jackson?
Yes.
So, Mr. Jackson, I apologize. I did not see that you were in the waiting room, and because court started at 9, so I don't know exactly when you showed up, but Mr. Lee was here and we already had your hearing. So make contact with Mr. Lee. You're breaking up, Mr. Jackson. I can't hear you at all. I mean, I can hear you, but I don't know what you're saying. Okay. Contact Mr. Lee. I'm moving on in my cases.
Noel McLean appearing on behalf of the respondent, Tucker Sandana.
Do we have Ashley Swindell?
Yes, Your Honor, I'm here.
Okay, thank you. Be just a second here. And I apologize, Ms. Looney, you were indicating what now?
Well, Your Honor, when we were here last, Ms. McLean had indicated she'd been served with a proposed child support order and worksheets, and that at that time, I believe Judge Fassett was presiding and said that those were not available to the court. The state has not received copies of that either, and I don't know if the court has them at this point.
I had received a motion from Ms. Swindell, which is the motion for, I think it's number 13 on your docket. Ms. Swindell had filed a motion asking this court to modify the temporary orders by changing the parenting plan and the child support order. And we've objected to that, but.
Do you know when that was filed?
I received it on May 23rd. It looks like it was filed on May 17th with the court.
Okay.
And so some of the difficulties that we're having is that Ms. Swindell will serve my office, have hand delivered to my office, or email us certain documents, but they tend to be different than what's filed with the court. So I had received I think it was a hand delivery, or no, it was an email delivery that included a proposed child support order. But I don't know I don't see where that's actually been filed with the court, just a proposed parenting plan, it looks like.
So when I went to go put them into the court, they told me to contact child support. I have not been able to do that, and they didn't take those forms. And I had already scanned that all in and accidentally sent it to you as that.
All right. So the two things that I know are on was the contempt and the mother's motion. So are you saying, Ms. McLean, bottom line is you don't have the same documents that have been filed? Is that what I'm understanding?
I have more documents than So I do have a proposed child support order and worksheets from Ms. Swindell. She did not serve the state, and apparently the clerk's office did not accept those documents, but I have received them. I don't know if the court has proposed orders from her that include the child support order. She's asking to modify the parenting plan to change custody back to her, and she's asking to modify child support. And those are based on her motion that appears to have been filed on May 7th.
So what I have in regard to the parenting plan, but I do not see anything as to child support. And maybe I'm missing, sometimes it's hard to tell from all the documents and what is what, but I don't recall seeing any child support. And you're telling me, Ms. Swindell, that they didn't accept those documents, is that correct?
Yeah, that's correct. They referred me or they told me to go contact the child support people.
All right, so Ms. Looney, sounds like you have not been contacted yet.
We have not, Your Honor.
Okay. All right, so let's just start with that matter then. If the child support is not in here, the state has not been contacted, then it doesn't make any sense to proceed forward with that particular matter. Ms. Swindell, would you agree, since I don't have everything?
Yes, Your Honor.
Okay. All right.
And I would simply ask that the court reserve my client's request for attorney's fees, because technically this is the second time we've been here on this motion. We were in front of Judge Bassett on this motion on June 18th, which was set over to today's date. So I would just ask to reserve fees.
That would be reserved. Ms. Swindell, please reach out to Ms. Looney in regard to child support and get those served on their office of what you're proposing and your contact information. Ms. Looney, anything else that you need?
Your Honor, I can give her our physical address where she can drop off copies of her documents.
Thank you.
Mm-hmm.
All right. So let's go ahead and address the contempt matter.
Yes, Your Honor. So as I indicated, I do represent the respondent, Tucker Sundana. We are asking the court to enter a finding of contempt against Ms. Swindell for violating the parenting plan as well as the restraining order. Your Honor entered the temporary parenting plan and restraining orders in this case on March 19th, so earlier this year. Our position is that Ms. Swindell has violated paragraph 4A1 related to the visitation. She's violated paragraph 4A 2D as in dog, related to not consuming illegal or legal substances without a prescription from her provider, and violating paragraph 4B1 for not obtaining a collateralized substance abuse evaluation. As can be seen from our sealed health documentation, Ms. Swindell tested positive for marijuana on May 3rd. Actually, she had submitted one on May 3rd of 2024. I'm sorry, she had submitted one subsequently to that. We waited 7 weeks from her last use. And so on a UA, her system should have been clean within 30 days. And yet the sample was nearly 5 times the cutoff limit. And not only that, she tampered with the testing because it shows that it was dilute. It is clear, even from her responses, that she's not stopped using marijuana. And now she's trying to suggest that she needs to be prescribed marijuana by going to a facility that's going to issue her a prescription just for the payment of a fee. The parenting plan provides, again, that she's not to use any substances, and we specifically waited to ensure that those would have cleared her system. But again, she continues to use in violation of the court order that prohibits that use. The parenting plan, as a result of that, has terminated her visitation and contact with the children. And I would also note that the restraining order, also entered back in March, prohibited her from going to the school or coming within 500 feet of the children's school. The parenting plan also prohibits her from allowing the children to have contact with her significant Jason Musso. And so what you see from the original motion is that she went to the school, she dropped off a birthday gift for Jada. We provided proof of the gift and the cards that were delivered on May 17th. And then a second time, she sends her significant other, Jason, to the school to deliver documentation for the children. Simply inappropriate, in violation of the court orders and in violation of the fact that she's not supposed to be having any contact with these children. It is clear as well that she has not complied with the court's order to participate in a collateralized substance abuse evaluation. The assessment that she provides is a one-page statement from Cowlitz Family Health Center. It does not include the information as far as any UAs that may have been collected at that time or what the results of those UAs are. It also is silent as to any collateral contact related to my client. And he tells you specifically in his declaration that he's not been contacted to provide collateral input for a substance abuse evaluation involving Ms. Swindell. And as far as we know, the guardian ad litem has not been contacted to provide that collateral information. There is no valid prescription for marijuana. And quite frankly, the suggestion that smoking marijuana is an approved method of administration for THC, there's no way to measure how much THC is being ingested. And obviously, marijuana was a concern with this court and Ms. Swindell's parenting, and she's simply attempting to try and legitimize her addiction. So we're asking that the court enter findings of contempt for willfully violating the provisions of the restraining order and the parenting plan. We're asking the court to order her to comply with the evaluation process. She should be required to do that within the next 30 days. We're asking the court to enter sanctions of $100 and attorney's fees of $1,500. And that in order to purge contempt, that she is to comply with all court orders. She's not to attend the children's school or contact the children directly or through third parties unless ordered by the court. Again, participate in that collateralized substance abuse evaluation within 30 days and to pay the judgments within 90 days from entry of the order with the court. And I have provided the court a proposed contempt hearing order.
Ms. Swindell?
Good morning, Your Honor. So I've been pretty open with my use of marijuana. I'm open with my doctors. I'm open with my therapist. And yes, I never went and got the medical marijuana card because there is a fee to it. And I just didn't feel like it's legal. So it's state legal. So I didn't feel like going and getting one until this happened. And then when he started using it against me, I went and was getting a legal marijuana card. Because he's known about my use of marijuana because him and I both smoked marijuana together when we were together. So my doctors are very aware of my use of marijuana. My therapists are aware. He was aware, and I just wanted. So I did fail that UA. I have been a daily marijuana smoker for over 5 years. It stores in your fat cells. So if you are just smoking marijuana a little bit, then yeah, it'll be out of your system in 30 days. If you are smoke daily.
And I guess I would object as to her testifying as an expert. There's no qualifications that she has sufficient education or knowledge to be identifying how quickly marijuana metabolizes.
So the court understands that and understands what is acceptable and what isn't. We'll give it the weight that it deserves. Go ahead, Ms. Swindell.
I also want to bring up that Mr. Sindana had no problem with me smoking marijuana until I filed for full custody of our oldest son because he was having anxiety issues, and him and his father butt heads quite frequently. I've been trying to keep it very fair. I've been trying to avoid this entire time. I'm trying to do everything right. I do have the UA from the eval that I did that shows marijuana and nothing else. I passed a UA for my job that showed marijuana and nothing else. I did a hair follicle test that showed marijuana and nothing else. But yet Mr. Sindana, when beginning this case, had his attorney try to make it sound like I had substance issues that were bigger than just marijuana. And that's what led to this. He's been frequently exaggerating things, just like our last court that he tried to get a restraining order on my boyfriend, and his girlfriend tried to get one on me and on my boyfriend too. It was on November 7th of 2023. I have the number of it. It was thrown out because it was so exaggerated. They have been keeping me from seeing the kids. The moment the court issued the documents of the no contact order, he went to their school, he went to their doctors, he went to their therapist with a copy of it saying that I'm not to be contacted for anything. And it clearly states in the parenting plan that I should be on there before any other, me and him only, and I still should have contact with schools, even though I cannot be at the school. I didn't go to the school. I had my boyfriend drop something off. He did not talk to the kids. He dropped it off in the office because his daughter goes to the school right next to it. He dropped it off in the office. He dropped off a birthday card from me and my uncle. That was it. Nobody talked to the kids. Nobody seen the kids. I did not go to their school, but they're exaggerating. Again, this is a habitual thing. He's using the legal system. He's using and this is just, it's getting to be so much that he's now trying to record us talking on the phone without my permission or the children's knowledge. It's getting crazy. And I understand that we have until we've been assigned a GAL and she's done her investigation, but it's not due for another couple of weeks. But I really think that the court will see how much this is getting exaggerated and how much this is ridiculous. I can't afford an attorney. I'm trying to work and pay child support, raise a toddler myself. This is crazy. And I guess that's all I really have to say.
Ms. McLean?
Well, obviously, she acknowledges that she has continued to smoke marijuana in violation of the court order. She acknowledges that she sent Mr. Musso to the school in violation of the restraining order and in violation of the temporary parenting plan, which specifically states at paragraph 4, A to E, the mother shall be enjoined and restrained from allowing the minor children to have contact with Jason Musso and or Kiana Musso or any known domestic abuser, drug user, or individual under the influence of alcohol or drugs.
Objection?
Her choice.
Can I say something?
What's your objection?
They didn't have any contact. There was no contact made. So I don't understand this.
Okay, you've had your turn. So let me hear from Ms. McLean.
So she sends the individual who she knows is not to have any contact with the children to the school to deliver items. And again, the restraining order prohibits her from coming within 500 feet of the school. There's absolutely no evidence before this court that my client has prohibited her from having contact by phone or email with providers. There's no evidence of that. It is accurate that the providers have been provided the restraining order to make sure that they're aware that she's not supposed to come within 500 feet of those facilities. And yet she's violated. So we're asking the court to grant the relief as requested.
I've reviewed the files and record, heard the argument here today, and the court does find that Ms. Swindell has intentionally, maliciously and intentionally violated the court order, restraining her from going to the school. Whether it's directly or indirectly, Ms. Swindell, that still meets the requirement of not having contact or going to the school. So if you send somebody with something to the school to give to a child, that's no different than if you're standing there and give it to the child. So also in contempt, as well as consuming marijuana and not obtaining the evaluation that was ordered, it is irrelevant as to the motion as to whether or not the respondent has smoked for purposes of this motion. You can purge the contempt by coming in compliance with the court order, including obtaining the ordered evaluation within 30 days and comply with the court order. You will be required to pay a $100 sanction and $1,000 in attorney's fees within 90 days of entry of this order. Ms. Swindell, you've been told no marijuana, no smoking, no having it, and yet you continue to do it. Whether you think that's okay or not, you're going to continue to follow through, or you're going to continue to have contempt motions brought, I'm sure. But it also weighs heavily on whether or not you're willing to follow a court order. And from what I can see, you are not. So with that, I will be signing off on the order.
So the court will need to make changes at paragraph 1 and 8 to reference the $1,000 in attorney's fees. And I will provide Ms. Swindell, Ms. Looney, and Ms. Evald with conformed copies of the orders once they're available on Odyssey.
I've made those changes. Ms. Swindell, are you okay to put approved via Zoom?
Yeah. Yes, Your Honor.
The only other thing that I would ask is if the court is willing to add in the language at paragraph 13 about reserving respondents' requests for attorney's fees relative to petitioner's motion to modify.
You can just bring that up if
Okay.
it's back again.
Okay, I'll just reference the clerk's notes then. Thank you very much.
Crossover.
Okay.
Your Honor, present for Mr. Baldwin in this matter, the petitioner.
Amanda Holder for the respondent in this matter, Stephanie Baldwin.
All right. So counsel, I know that you were working on possibly an agreement on some things. I don't know if issues are narrowed or where things might be.
I think we still need the court to make determination. The primary issue, I believe, is whether visitation would be overnight or limited to just day visits. That's where we've had a hang up primarily. So I think it's just argument, Your Honor, and in the course of it, I think frame as best we can what those issues are. The only additional, Ms. Holder and I spoke this morning. Your Honor able to see it in our reply declaration. My client indicated that the two of them had continued to engage in a romantic relationship past the point of the filing. That did functionally continue until the current order was entered that restricted contact the family wizard. The parties haven't had any romantic entanglements since, but it did continue past the filings of the parties. Something I think both attorneys may address, at least in passing. It's not disputed, but I just wanted Your Honor to be aware that that may tangentially come up, even though it's not specifically in the declarations, and Ms. Holder and I spoke about that. I don't think there was anything else framework-wise. Ms. Holder, anything otherwise?
The only thing I can think of, Your Honor, is that decision-making component, as well as what we ideally would like to do is have the court rule on overnight visitations or visitations generally, decision-making, set a presentation of orders for hopefully 2 weeks out, and then we can make some arguments about finances. Right now, my client has not filed a financial declaration. Her circumstances have changed a little bit since our pleading and our responsive pleadings. And so we would ask that a presentation of orders be set out for about 2 weeks. That will give Mr. Baldwin and I time to exchange some further financial information, have any type of responses, and then the court could reserve on finances today and make a decision at a presentation of orders hearing in 2 weeks from now, ideally.
And that's agreed, Your Honor, as far as dealing with the financial. I was just setting it to address at a presentation on the parenting plan and visitation so that a filing can be done. And if we can work out an agreement by then, great. And if not, the court will have all the information it needs for financial purposes.
Okay, go ahead.
Yes, Your Honor. This motion was originally brought by Mr. Baldwin pro se. He did information for temporary parenting plan functioning as his initial declaration. He identifies a loving, stable relationship with his children, an active involvement, with the exception to attending to their educational needs, because at that point they're young, and the schooling that they were doing, I think, was functionally through homeschool with mom. But that he was an actively engaged and supportive father, and also identified the same as to Miss Baldwin. His request in his initial petition and temporary parenting plan on the motion for temporary orders was for every weekend because of his work schedule and because mom, generally speaking, is home during the days with the children. We will get into more detail on finances later, but she does work part-time and does a home sale business functionally for income. And as a result of that, she's home with the children during the day, during the work week. So his request was for every weekend. In the course of our discussion, a proposal was a more standard every other weekend plan. The court's remiss, even if a parent primarily works from home, to give one parent over the other every weekend. So my client's declaration, reply, identifies requesting the court grant him every weekend, and if not, in the alternative, granting extended weekends on an every other weekend basis, so he's able to continue his involvement and engagement with his children. Ms. Baldwin, in her response declaration, alleges that that's not true, that he's not an active or engaged father. He denies and disputes that. The main crux of her responsive declaration is allegations that there are concerns of safety with my client, with some generalized accusations and allegations of domestic violence behavior during the relationship, specifically including text messages from a period prior to the 24th of April of this year, where my client admittedly in his declaration used improper and unkind and inflammatory or even aggressive language out of frustration with Ms. Baldwin. His declaration tries to detail in the best way it can the context of what was going on. In an effort to do that, we highlighted the text message conversations, but provided context to the extent that the court has the opportunity to review a significant amount of declarations, text messages between the parties, but his declaration highlighted specific pages in an effort to try and reduce how much the court had to look at, but wanted to give as full an observation of the context of the text messages that were alleged by Ms. Baldwin as causing her concern. The most important issue here, and there's really, I think, two pieces to it. Her request for limitations on my client, did he get an anger management evaluation, which he has had, but we don't have a result yet. It's been several weeks. We were hoping to have it before court today to file, but we don't have any results for the court from any evaluation, is because of the type of language that he used and concerns for safety, indicating in her declaration that there were cameras put up for out of her fear of him being in and around the home. Contemporaneous with that declaration, what is unstated by Ms. Baldwin, and what I think the attorneys were unaware of until it came to light around the time of my client's reply declaration, is that the two of them continued to engage in a romantic relationship throughout the entirety of the case. That is the context that I think is key to my client's outburst in the text messages when he's accusing her of cheating on him. It is not a historic claim or an accusation that something happened during the marriage causing him to leave, and months later there are continued anger or aggression. It's that while the Facebook posts are being posted by other individuals to and about her, or things are posted on social media, well, the two of them still had access to view each other's social media. She appears to him to be engaged with another man, all while in his mind they're working on their marriage relationship and continuing to have a sexual relationship that continued even past that point. The thrust of Ms. Baldwin's allegation that there should be limitations on my client is that she is fearful or he is dangerous, and in the same breath she's sending him text messages, inviting him to the home, having him come around the children, but exerting what he identifies on his initial declaration, brief as it is, that this is an issue he sees of control. She is demanding that for him to see the kids, he has to come to the house, or setting her own restrictions and guidelines that inevitably bring the two of them together and result in continued physical intimacy that my client very clearly in the scope of all the text messages is identifying as romantic intimacy. And in the one hand, giving him the belief in what appears from his messages and even declaration to be hope that the two of them would reconcile, somewhat countered by the fact that she appears to him and in some of the messages posted by others be actively engaged in physical relationships with others at the same time. She claims in her declaration that he is a danger to her and a danger to the children, such that he should not be around them overnight or even at all, and simultaneously is texting him when she doesn't come over for a planned dalliance that he's always free to come over there. He can come over anytime, that he's welcome there, in caps that it's our home, not her home. And his responses are showing anguish and pain at the feeling that he is not wanted and being used. His intention was to end the physical relationship. They didn't. They continued to have additional interactions and sexual dalliances until the parties entered an agreed order limiting contact to be through Family Wizard, and an outside the box restraint telling the parties that they are not to interact. And I think at this point that is appropriate because the parties need space to be able to move on and heal. The other piece that I think is somewhat important, it's referenced in my client's declaration. One of the limitations, I believe, and it may not be in the declarations, but that Ms. Baldwin is asking for is that there be limited contact with my client's mother. There's reference to, in both his initial filing and reply declaration, a protection order initially filed by Ms. Baldwin against my client's mother. That was filed here in Cowlitz County. I believe the cause number was included in the pleadings. Pardon me. It's 24-26108. In that, Miss Baldwin alleged that Anita Baldwin, my client's mother, strangled her and assaulted her. That resulted in a temporary order of protection that forced my client out of his parents' residence, who were giving him a place to live while they had initially separated. And ultimately, at a full hearing, resulted in a denial of the protection order by Judge Basher, and under the findings indicating that evidence is the petitioner is the aggressor in the situation. A specific notation and finding by Judge Basher in that case. I believe the request that my client's mother not be around the child is because subsequent to the protection order being dismissed, and it's referenced in my client's declaration, criminal charges were filed against Ms. Baldwin in misdemeanor charges involving against my client's mother in Oregon where they occurred. So we don't believe there should be any restriction or limitation on my client's family being able to be around the children's mother specifically. As to decision-making, I think if there isn't a finding of any 191 factors, I don't believe at this point the court should enter any. Our position is that they should be joint. I know one issue that may ultimately come up, I think the parties are requesting a GAL, or at least we're not opposing a GAL, which was requested by Ms. Holder and their responsive filings back on the 24th of April. Because the children had been homeschooled, and I expect there's going to be a dispute moving forward about the children's school, whether they should go to public school or continue to be homeschooled, and a GAL should be appointed. Otherwise, I think decision-making should be joint with the general caveat that either parent, while they have the children, should be free to include the children in religious practices. We're asking my clients, again, original pleading with mom being home with the children is every weekend based on his work schedule, and the alternative alternating weekends on an extended basis of Friday to Monday and a midweek on the off week, that there's no basis for limitations preventing him from having overnights with the children. Again, we'll note one of the exhibits in my client's declaration, and it is exhibit, I believe it was exhibit C, conversation 3, after the events that are the basis of the declaration and text filed by Ms. Baldwin on April 24th. She had my client watch the children because of, I believe it was a work issue. The text messages on that conversation are of him receiving the children to watch them around 2 to 3 in the afternoon, her requesting that he provide a phone call when the children are going to bed so that she can say goodnight, a courtesy she identifies that she generally provided to him. And then around 4 o'clock in the morning, asking if he was up because she was now free. That's the point that she went to pick up the children as identified in his declaration. So even with her concerns alleged, I think the overall scope of the text, the context, and the subsequent contact and interaction both with her and lack of concern of his interaction with the children obviated any need for there to be supervision. There's a specific instance where she had him watch the children overnight after all of the events that formed the basis of her declaration occurred. So I believe the declaration is fairly full, and I don't want to belabor the text messages. As I said, Your Honor, we attempted to give context as best we can, but to highlight the specific instances that are related to the allegations by mom and her response declaration, so as not to appear to be hiding anything, that this is a situation where breakups are, as the court sees on a regular basis, a dozen or 2 times every Tuesday, they can be messy. There are continued emotional entanglements, and that affects both parties. It's evident in mom texting him about people he's around and attacking their character and using inflammatory, profane language. And it's reflective in him responding to seeing someone on Facebook talk about something sexual with his wife when he believes they're, even though there's a filing, on a path of reconciliation where they continue even after her filing to be intimate with each other. That the allegation that there's concern or fear for the safety of the children is hollow, given her actions allowing him and inviting him into the home, and that he should have visitation with his children. We do think a GAL should be appointed, and possibly even a scenario where an interim review may be appropriate to look into some of the issues with it being summertime for school and the concerns of the parties, but that there is not a basis for restriction or limitations. That's our request at this time, Your Honor.
Ms. Holder?
Yes, regarding the visitations, it's pretty clear from the pleadings and from text messages, this is a very volatile relationship. It can go from good to bad pretty quickly. My client and Mr. Baldwin engaging with each other, sometimes happily, sometimes not, is a pretty classic indicator of domestic violence behavior. and wherein a victim will repeatedly return to an abuser. It's pretty clear also from the text messages that Mr. Baldwin most certainly needs some anger management classes and evaluation and treatment. I believe Josh Baldwin and I both agree that our clients are going to undergo evaluation and treatment. Because my client has been the primary caregiver throughout the relationship, being a primarily stay-at-home mom, educating the kids through homeschool, only having a part-time job to make ends meet, and not having a full-time job upon agreement of the parties. She should have sole decision making for their education, as she's been the primary educator, healthcare decisions, as she's been the one to historically attend all of the children's doctor's appointments, and sole religious decision making, as it's very important to my client that the children go to church every Sunday, which they have been doing, as Ms. Baldwin believes that not only is it good for them religiously speaking, but it also gives them some structure, as not having the structure of a traditional school environment. When it comes to the visitations, my client would really prefer, and I think it is necessary, that there be no full overnights until Mr. Baldwin has been evaluated and he is compliant with anger management treatment. It's very clear that sometimes my client is okay with having the children over, sometimes she is not. It's also very clear from the text message conversations that sometimes the parties work together and agree and are loving towards each other, and then a shoe drops and the parties are no longer working together and they become very volatile. I think it would behoove both parties to not only undergo anger management, but also parenting classes for father here, as well as parenting classes. He's never been a primary caregiver. While he might have been active in the children's lives, he has not been active to the point that he has been caring for their daily needs, and we are dealing with younger children here. So we would ask that he undergo parenting classes as well. Regarding the visitation of not wanting Mr. Baldwin's mother or family members to be involved, this was an altercation that happened in front of a 4-year-old child. There is a family history for father's parents and family members. They have multiple felony convictions. My client just doesn't want the daughter and her son to be around convicted felons. And also, the child is now in therapy specifically related to the incident that happened between my client and Mr. Baldwin's mother. So that's why we are asking for the limitations on the children not being around his family. When it comes to the financials, we haven't really discussed it, but my client, again, is a stay-at-home mother with a part-time job, homeschools the children, and that was an agreement by the parties. So we would, when we are deciding financials, hopefully 2 weeks from now, we would hope the court would take that into consideration, that normally we would impute minimum wage as being purposely underemployed, but this was an agreement between the parties that she would be a stay-at-home mom, primarily taking care of the kids and their educational needs. Mr. Baldwin and I both agree that a GAL is necessary here. I think it's really important to kind of get to the bottom of what's going on. We get one picture from the text messages and we get another picture from the declarations, and I think that the children will have a lot to say regarding what's going on here, especially when it comes to a permanent residential schedule. I think it is very clear here that this is a toxic push and pull dynamic between the parties. There's a lot of uncovering of information that needs to happen before any permanent decisions can be done. But in the meantime, we would ask that visitations for father happen every other weekend with no overnights until father is compliant with an evaluation and treatment for anger management and parenting classes. And we would also ask that the mom have sole decision making when it comes to education, healthcare, and religion, as she historically has had those decisions. That is all.
Yes, Your Honor. So first, therapy regarding the incident that was alleged also in the protection order case. I'll say for the court, this is some of that is outside the scope of the declarations, but we have had a discussion that we're going to give the court as much as we can, and trying to limit that here, Your Honor. The scenario of that incident is Miss Baldwin taking the child to my client's parents' residence to return items of his. There's a video recording that was, I believe, a part of the protection order case, that it was a part of what occurred there. So the scenario that she's describing, that Ms. Baldwin has described to her attorney, is not so simple as the child was there to see this incident. Miss Baldwin took the child in her car to the grandparents' home to, in the video, throw a box of my client's belongings on a vehicle in their driveway, and then go to leave. And when my client's mother saw the child in the car, said something like, "I love you, baby, it's okay." The child started crying because of what was going on. Mom got out of the car, and that brought about the charges in Oregon. So it's not a scenario where the child's trauma is as a result of any action besides Miss Baldwin's. And it's not in substantively her declarations or request up until this point, because at the time those things were filed, she had yet to be charged with a criminal offense against my client's mother. And I think it's though guised in the context of concern, it's retaliatory. As for the financial, I'm asking the court to reserve because those things aren't filed. My client hasn't had a chance to respond to specifically those, any allegations. I know Ms. Holder is going to file potentially a declaration from her client with time for me to respond with a set over of a presentation so we can get that before the courts. And the session court to reserve on financial. As for the sort of generalized statement that the behavior of Miss Baldwin is in some ways indicative of domestic violence, I think both parties should get an anger management evaluation or DV. I say that my client's got an anger management evaluation because that's what was initially requested. And I don't believe the evaluator did a DV component. But I think looking at the text messages, it is clearly indicative that my client has a response that would typically be the responses that are on the side of the DV victim and not the perpetrator. Looking at Exhibit C, conversation number 1, it is a conversation about Miss Baldwin not coming over for a planned sexual dalliance. She's talking about in the messages, thinking about their time together physically, and his responses are, "You didn't care enough to come here. You didn't care enough to come here last night." Her response is, "I told you," this is page 2-3, "you every other time you can come to me, make me feel special." And he says, "I'm not doing that again." And he is talking about not liking the way he feels. "I'm not going to let you make me feel that way. I've never been enough for you." He's the one coming from a place of hurt. And her response at the end of all of this, at page, it goes 7, top of page 8, back and forth, becomes him asking what time to get off. She says, "Midnight. If you come here, there'll be no talking." She says, "Okay." At 12:40 a.m., she texts him, "You up?" He responds, "Yes, but late," because she got out at 12:30 and he was asleep. And again, he is feeling and acting and identifying that he is hurt. This is not a scenario where he is abusing her or he is creating a scenario where she is incapable of breaking free, which is what she basically puts in her own declaration response. She's the one who texts him, "You up?" She's the one who is initiating. He's the one who's hurt when she doesn't follow through. Men can be victims of emotional abuse just the same as women can. And I think at this point, it is clear, my client says it too, they're passionate people. And I don't disagree that there is a toxicity to their relationship that needs to be broken. But none of that creates a scenario where there's any basis for the court to deviate from a general presumption that he's able to care for his kids. He says that he can in his declaration, and her statements to the contrary and hers, I think, are at least significantly refuted by the other statements she makes that are again, observably false. She says she's afraid of him and that she's broken free and that he's following her or tracking her or doing these things to cause her fear and concern, all while she is engaging with him physically and emotionally. He felt strung along. At one point, he said things he should not have said, and he acknowledges that. And since then, there's no other incidents of him losing his composure and calling her the names that he called her that were the basis of the declaration on the 24th. I'm asking the court to give him his request initially every weekend. I acknowledge at this point, even though that fits the work schedule and the assertions that mom is at home with him during the day and then in the summer in particular wouldn't need the weekends, that if he's only getting every other weekend, it'd be extended, that it'd be overnight. I'll also note that while she's saying that she is not working and she is tending to the needs of these children at all times. She's texting at 12:40 after getting off. I got out at 12:30 at night, a.m. in the morning, and she's not with the children at 12:40 at night. So I don't think that it is as cut and dry as it's laid out by mother. And I do think the GAL will get to the bottom of a lot of these things, but in the interim, my client has been functionally withheld or limited visitation with his kids since the filing. And
let's wrap this up. I have a number of other cases. Anything else?
No, Your Honor, that's all.
All right. All right. So I've reviewed the files and record, and based on that, a few things. First off, Mr. Baldwin, real quick, what is your client's work schedule like? I don't recall if I saw that.
His initial pleading, about 7 to 3-ish, Monday through Friday, is what it was initially. He's present. He can confirm if that's not correct, but that's what I understood it to be.
Okay. All right. So with that, the court does have some concern. On one hand, I see, the issue of making an issue by mom when yet they continued. What's going on there? Who knows? There can be a possible large number of things. But in regard to what's going to happen for now, and understanding this is for now, because I want things looked into and to figure out what's going on and try to get to the bottom of some of these things. But this is going to be a bit unique because mom is at home and working just part-time. But it's not going to be every weekend. It's going to be the first, second, and fourth weekends. So mom will have every third, and if there's a fifth, mom will have that. And it's not going to be Friday through Sunday. It's going to be Saturday at 9 a.m. to Sunday at 6 p.m. And then for the weeks that he does not have the weekends, he can have the children from the time, if he gets off at 3, I'll just set it at 4 o'clock till 7 o'clock on the off weekends, or off weeks, I should call it. I do want anger management evaluations with input from the other party, and I kind of have gone back and forth because it sounds like maybe there are some possible issues on both sides. And so I want both parties to have the anger management evaluations. I do want dad to go ahead and have parenting classes that are age appropriate. I'm not dictating as to what that might be. And then the financial part of things is reserved. Social media. This seems to be a downfall of all domestic cases where somehow people think it's okay to post what's going on in their life, every bit of what's going on, or have other people post. No posting by either party about what is going on in their relationship and what's going on here in the litigation of matters. It's not appropriate. And so with that, no social media posts. In regard to religion, both parties have a right for those children to experience whatever religion that they choose. So I'm not going to have it where necessarily the children are going to be at the same church. Will it be helpful and more stable for the child? Certainly. So if they can work that out, great. But otherwise, they have the right to their own choice of where they go. I do want them to use the family app and to stop using their regular texting. At this point, I am not ordering any 191s. I'm reserving on that. I also do not want the children around the family of the father at this point. And then meanwhile, let's go ahead and appoint a guardian ad litem. I think we have a plan that will get us through until we get some interim input from a guardian ad litem. So who would be the next three?
Heather Call, Keith Lawrence, and Twyla Corey.
Strike the first, Your Honor.
Okay.
I'm fine with either, Your Honor.
All right, so we'll go with Keith Lawrence. I don't have very much financial, but I will make this private pay and at the same rate as their child support.
Your Honor, I do believe my client may qualify for county pay depending on her financials. If we could reserve on her payment for the GAL until the next hearing, I think that would be appropriate.
I have no problem with that, Your Honor, because we won't have the child support percentages until that hearing. We'll have the order ready and can just make that adjustment at that time if that works for Your Honor.
Okay, that's fine. All right, so you want it set out a couple of weeks? Is that what I heard?
Yes, Your Honor.
Okay, July 16 for presentation and also for the financial part of things.
And just to make sure, Your Honor, this being the second weekend of it's the first weekend of July, yesterday being the first, so he would get this weekend, just to be clear. Perfect.
Right, so it would be the first weekend, so it'll start this weekend.
Perfect. And I'm sorry, Judge, I missed, what was the date for the presentation? I apologize.
The July 16th.
Wonderful.
I'm sorry, I have a quick question if that's okay.
You can call my office, sir. I can answer any question you got.
Thank you.
And Your Honor, I do believe you have not ruled on decision-making for education or healthcare.
Oh, that's right. So in regard to decision-making at this time, I am going to go ahead and make it joint. That's why I actually used the family app. I want to see if these parties can try to redirect where they're at and try to have some conversations, like input from the guardian ad litem. If we need to change it, we'll do that. But again, both parents have a right to have input, and I'm not seeing any basis to restrict at this point.
I'm sorry, one last question. I apologize. On the off-week visits after work, I didn't hear what days, and I want to make sure that I have that down correct.
So at Thursdays.
Okay, perfect. Thank you, Judge.
Okay.
If that ends up being an issue, you can resolve it. No, Your Honor, I don't think there's anything else at this time.
Okay. All right. Okay, we have Ms. Bliss present here. Ms. Dow is online. So this is a motion to modify the parenting plan.
Your Honor, actually, this is a motion for a new temporary family law order. It addresses the parenting schedule.
Okay, go ahead.
Just for the record, Mr. Broderius is also present here in our offices. Your Honor, Mr. Broderius's declarations lay things out pretty clearly, so I'll just sort of hit the main points here. Since this action has been in place, we've had some false starts and some rough patches here, as Your Honor is well aware. But he's followed the court's orders. He's done everything he's been asked to do. He's worked hard to address the problems his behaviors caused 4 years ago. He doesn't deny that it was his behavior that triggered this. He's significantly improved his ability to handle anger or frustration, especially for appropriate responses to children. He had a domestic violence evaluation. He actively engaged in and completed a DV program. He completed a parenting class. At the last hearing in December 2022, the court ordered counseling for the children, especially for his son, with an emphasis on strengthening the bond between Mr. Broderius and the children. That particular schedule has been entirely in the hands of Ms. Despain, and it has not happened. But that's the only thing that hasn't happened. He's had supervised visits with his children for the past 3 or 4 years, only interrupted by COVID restrictions or some shorter time frames due to some financial limitations. He actively sought guidance from the professionals at the Reconnected Families Visitation Center. He took things very slowly because of his son's autism and ADHD issues, and to work on his parenting skills. He's remarried. He's been acting as a stepfather for a child the same age as his daughter for the last several years now. With Ms. Despain's agreement, he moved into unsupervised time for 3 to 4 hours every Sunday with both children for the last 6 months. They moved into unsupervised time through agreement with Ms. Despain rather than coming back to court, because Ms. Despain did not want to start with an enforceable court order. Mr. Broderius wanted to get started on a transition to regular parenting plan, so he agreed to that. Those visits have gone well for both children. His son Bentley has attended, if not every single visit, then the majority of them. We are asking to move to the next step, which would be overnights. Mr. Broderius has taken pains together with his current wife to educate himself about his son's autism and the ADHD diagnosis, which kind of overlap for the child. He's prepared to adjust his time as Bentley needs. But we would like the order to allow for the same regular time as for his daughter Bailey. The children will be staying in a settled 2-parent household with another child, one that they're acquainted with. They go to the same school together. They're acquainted with his new wife. In spite of Ms. Despain's claims, the children haven't shown any hesitation in their limited interactions with her. They seem to be fine. They know that going to Dad's house means that they're going to be there with Emily and her daughter Maddie. He and his wife are currently looking for a larger home, but he's perfectly able to accommodate the 4 overnights a month that we're asking for here. He works alternating day shift and swing shift. He'll be home on the weekends and the afternoon that we're requesting. So he'll be with the children. They're not going to be with a new stepmother on their own. He's also fine with the idea of having a GAL involved in this next step. At the last hearing in December 2022, the court ordered Ms. Jones to remain involved. And we're fine with that if the court feels that it's necessary. We've been in touch with Ms. Jones and she is available. So we are asking the court to put an order into place that moves this transition up to the next step.
Ms. Bliss.
Thank you, Your Honor. I'm Carly Bliss on behalf of Shauna Despain, formerly known as Broderius. While I appreciate Mr. Broderius's tact in all of this, spending the last 4 years with professionally supervised visitation, having 3 hours of unsupervised visitation for a period of 6 months, and then now asking for 48 hours with the children, I think that that is, despite his claims and his declaration of being reasonable, I don't believe that that is reasonable. And I think that's contrary to both kids' best interests, especially Bentley. As the court is aware, Bentley does have a diagnosis of autism and ADHD. There's been significant litigation throughout the lifetime of this case where Bentley has refused to go to visitation. My client provides in her declaration that from June of 2021 to October of 23, he wasn't attending any visits. So there's a substantial period of time where there was no contact or very minimal contact at best. Granted, he has enjoyed the unsupervised contact that the parties have been exercising for the last several months, but frankly, to go from 0 to 100 is it's drastic, and without any sort of contact from Bentley's providers, which his counselors have been engaged throughout this process, throughout the entirety of it, has made several recommendations in this matter. Without any sort of contact with them, without any sort of contact with the guardian ad litem as to how this major transition is going to impact him specifically, I think is contrary to his best interest. My client is asking the court to maintain the current schedule that the parties have agreed upon, which is every Sunday for 3 hours until we can get some sort of input from a guardian ad litem or Bentley's counselor. My client provides for the court the agreement between the parties. She attached that into her declaration. Specifically in that, and what's ironic is the discussions about Ms. Settle and her contact with the children. If you look at that agreed order, so to speak, between the parties, it specifically says in there that no other party is to be attending these visits but Mr. Broderius. This has been a reoccurring issue. The court is well aware. Your Honor made several rulings into the protection order matter between Ms. Settle and my client. Ms. Settle's behavior is concerning at best. The fact that both Mr. Broderius and Ms. Settle continue to not only violate the protection order, which prevented Ms. Settle from having any contact with the children, but then once that expired, despite this agreement between the parties that she would not be present at visits, continued to allow her to be present around these children. My client understands that these folks are now married, but again, the behavior between the parties throughout the lifetime of this case, most importantly as it relates to Ms. Settle, is concerning that Mr. Broderius can't take his children's best interest, can't take a court order into consideration over that of his wife. So that is a concern that my client continues to have. Again, I do believe that some input from a guardian ad litem is necessary. My client's not saying that Mr. Broderius should never have additional contact with his children, but it needs to be a slow progression. We can't go from 3 hours of recently unsupervised contact to 48 hours every other weekend. That's just too drastic of a change for these two young children. Bailey's 8, Bentley's 6. And again, Bentley does have these diagnoses that do require some extra tact when making these major changes. As for the guardian ad litem, I do appreciate that Ms. Jones has remained named in this case, but from my understanding, she has had minimal, if any, contact with the party since 2021. We would ask for a new guardian ad litem to be appointed. Both parties did mention in their declarations, both past and present, some concerns with how that investigation occurred and the recommendations that came from that. And frankly, the parties just chose not to adopt the recommendations of Ms. Jones last time around. So my client is requesting a new guardian ad litem be appointed. I don't know if Ms. Jones is active on the registry. I understand that Ms. Dow has made contact. I have not had contact with Ms. Jones, absent some emails going back and forth between my office and her this morning while we've been waiting on docket. So at this point, Your Honor, we are asking that the parties' initial agreement of the 3 hours every Sunday remain intact, pending some sort of input from a guardian ad litem and pending input from Bentley's counselors.
Ms. Dow?
Your Honor, first I'll address the issues with Bentley. If you read the reports that were submitted by Connecting Families, the child had real problems making the transition between his mother's car and going into the visitation center. But the times that he did go in, he settled down quite quickly. He's no longer using his IEP at school. If you check the particular Exhibit B that we submitted with our reply declaration, the IEP remains in place at school, but it hasn't been needed. It's not being used. He's settled down considerably. My client is perfectly ready. If Bentley is having a problem, he'll bring him home to his mother. He understands that this is a situation that requires some calm, some patience, and an easy touch. But it's got to start at some point, Your Honor. We've had 6 months of successful daytime visits, new locations, new situations. The child has been coping, and Mr. Broderius has been reacting appropriately. As far as the issue with the stepmother, she has been in contact with the children twice. The first time was with Ms. Despain present, and it was at Mr. Broderius's home. The second time, she went to a ball game. The kids are fine with her, at least as far as their behavior with their father. Now, what they're telling their mother is anybody's guess. I think you can tell from the tone of what's going on in this case that Ms. Despain has a problem with Ms. Settle. But at some point, we're going to have to address that as well. Now, if Ms. Despain would like to have a different guardian ad litem involved, we're fine with that. We were suggesting Ms. Jones because she has been involved throughout. Judge Evans, back in December of 2022, felt that it was appropriate for her to remain involved because there's a lot going on in this case. The only communications that we have had with her have just been to check to see if she would be available. Ms. Despain's responsive declaration made a number of allegations that are just not true. Allegations about numerous photographs and police reports on violations of the anti-harassment order between her and Ms. Settle. There's nothing there, Your Honor. Ms. Settle was very clear about the only time it was violated. It was right after it was entered, and she had to pick her child up at school. Her arrangements had fallen through. There were no further violations of that. There have been no violations of any of the other court's orders. If the court feels that a Friday night, all day Saturday, and a Saturday night are too much, then let's start with one overnight. Maybe a Saturday overnight. All day Saturday, Saturday overnight, and come back Sunday evening. But we've got to start overnights at some point.
So I have reviewed the files and record. I'm familiar with this matter. In regard to what the schedule is going to be at this time, it is going to remain as currently set with the 3-hour time frame. So however you want to put that into an order, that's what it's going to be at this point. In regard to the guardian ad litem, Ms. Jones is not currently on the rotation, so she will not be doing the report. And so with that, I need the next 3.
Heather Call, Twyla Corey, Karen Lawrence.
I'm fine with Ms. Kale. Ms. Dow, do you have any objection to that?
Yes.
Okay.
We would probably prefer, I'm sorry, who was the second one?
Twyla Corey.
Twyla Corey. Perhaps Ms. Corey, she would be coming to this completely without seeing any trace of these people in the court.
Sure, that's fine. I have no objection.
Okay. So Twyla Corey will be appointed. It will be at private pay. And it will be in the same rate as child support. So do you need a presentation date or are you good?
Your Honor, I think your order is fairly clear. I think we can submit it ex parte.
All right. And overall, just so it's understood, at this point, maybe it is time to have additional, I just want to have somebody look into it and talk to the different parties, as well as in regard to, just figuring out and making a recommendation. The one thing that I forgot to add is at this time, I also do not want contact between the children and Ms. Settles. Again, that's something the guardian ad litem can look at. But for now, the children should not be around her.
Sorry, Ms. Dow.
I believe we're through.
Okay. And Your Honor, I didn't know if from the clerk's perspective, if we need a specific ruling that Ms. Jones is dismissed and Ms. Corey is reappointed, and we can throw that in the temporary family law order if that would be sufficient.
You can, that's fine. I don't know why there's not an order that would have already ended that, but so anyhow.
We can work that out.
Okay.
Okay.
All right.
Thank you, Judge.
Thanks, Judge.
And this matters before the court on respondent's motion for contempt against my client. My client was not served until the 18th, which is roughly a week short of the timeline required. This is the third motion within the last 4 months that hasn't been timely. Frankly, I normally just responded, but my schedule didn't allow me that opportunity and my client needs more time to respond. So we are asking the court to set over the contempt. We are also before the court on presentation, but we can potentially deal with that at the contempt hearing or now.
Just want to make sure you're Marcella
Yes.
Fragel? Okay. Ms. Fragel is present in the courtroom, just so you know.
Your Honor, when I filed the papers, they told me.
Hold on, ma'am. In regard to the presentation,
I have objections to that, Your Honor.
okay. So you've heard me say this to other people, they need to be in writing prior to. So I think at this point, I'd rather just set both matters over, but you wanted to say something about filing?
Yes, when I filed the papers, they told me that I had to wait to get the judge's approval for the date, and the judge approved this date. As soon as I got that, I served it to Tim.
Okay. I understand that, but at the same time, there's still, you have to put in a date or have a date that's far enough out. You'll look at some orders that have alternative dates. If they're not served by here, here's what the date is. If they're not served by here, here's what the date is.
I understand that, Your Honor, but I was told to do it that way.
I get it, but unfortunately you were given some bad information.
Yeah.
So at this point, we need to go ahead and set this over. I'm looking at July 16. Does that work for you, ma'am?
I'm looking. No, I have a doctor's appointment that day.
July 23.
That's fine.
Is more?
That works for me.
All right, I'll go ahead and set this over to July 23rd.
And what am I to do about my safety issues until then?
I can't give you any legal advice. You can talk to an attorney.
And Your Honor, I imagine my client will appear regardless, but can we waive his appearance if he does need to work, given the fact that we've been here so long today?
No, I think he needs to appear.
Okay, thank you.
08, the Weaver and Weaver matters.
Yes,
Your
Your
Honor,
Honor.
Christine Dow here representing Charles Weaver.
Good morning, Your Honor. Michael Trotter representing Susan Weaver.
I need to find out why Mr. Jackson is back. Just a moment. Mr. Jackson, is there something you needed? Mr. Jackson, you're muted.
Yeah, I was just checking, make sure it still worked because it wouldn't let me in earlier.
Is there something you needed?
No, thank you.
Okay, you remember that your matter's done for today.
Yep.
Okay. All right, Weaver and Weaver matter. Counsel, go ahead.
Yes, Your Honor. Thank you. We're here on petitioner's motion for temporary family law order. It appears I haven't had a chance to connect live with counsel, but it appears the parties are in agreement to request the court grant the order to sell the home. And so we'd like to move forward with that today, Your Honor.
Okay.
And Your Honor, I've had conversations with my client about this, and he agrees that it is unlikely he's ever going to be able to return to the home. So he agrees that it will be sold. Some of the other the other personal property will be disposed of. One thing we would like to ask, I have identified several options to deal with the Medicaid issue for my client. I have a meeting tentatively scheduled with him this afternoon. It may have to wait until maybe early next week. He's got some medical appointments. So one of the things I would like to ask, and this is kind of a token, but if we could have the order read that any proceeds that might be my client's share of the proceeds be placed into one of the attorney's trust accounts, preferably Mr. Trotter's trust account, until we get the instrument formally in place that will deal with his share of the assets and protect his assets, his access to Medicaid.
That work for you, Mr. Trotter?
Yeah. Yes, Your Honor. Yep, that does work.
The only other thing that I noted is at one point there was also something about selling the cars. I don't know if that was also a part of that agreement or what.
Those need to be disposed of as well. Neither party can drive, and
yes, Your Honor.
We've had discussions about this, that there's an auction company that the parties have dealt with for years, and my client is fine if the cars are sent there to be auctioned off.
Yes, and we're in agreement with the sale of the
You're good with
cars
that,
as well.
Mr. Trotter? Okay.
Okay. All right, so it sounds like you have an agreement, so it sounds like all is good. Anything else that you need?
Can we submit an agreed order ex parte for your signature?
Yeah, that's fine. Just sign off on it and put it to my attention and just remind me what it's for.
Okay.
Okay. All right.
Thank you, Your Honor.
Thank you, counsel. Thank you, Your Honor.
All right, we are back on the record. Williams and Williams.
Yes, Your Honor, I'm here, Dustin Williams.
Okay.
Good morning, Your Honor. Jennifer Joslin on behalf of Sarah Williams, who is present via Zoom. I believe her video is just turned off. Oh, it's on now.
Okay. All right. This is your motion. Go ahead. I mean, not yours, Ms. Joslin.
So, Your Honor, I'm here today because this case has just gone on for too long. It's been almost a year, and there haven't been any changes. I know there's no current order in place to enforce the recommendation given by Barbara, or what has currently been happening. That's why I filed this motion. The recommendation was given in November for us to start a phase plan. I asked Jennifer if we could enter an agreed order following that recommendation. At first, Jennifer reached out to Sarah, Sarah wanted to make some changes to that phase plan, extending the lengths of each phase. I did not agree because Sarah had already had input on the recommendation and had Barb edit her original letter before sending it out. She also would only agree with entering a final order. Jennifer told me that the court would be 2 to 3 weeks out, so I'd have to file a motion so that the phase plan wouldn't start till then. I was going to finish drafting the paperwork to file a motion, but Jennifer emailed back saying that Sarah had agreed and there was no need to file a motion. I filed the email threads that Jennifer and I had in the conversation of her asking for a counteroffer of the phases instead of going to court. I made it clear in my emails that we were agreeing that each phase was to be a 1 month phase, reaching phase 3 after a 3-month period of no safety concerns. This is how I understood that the phase plan would move to the reunification process along. They're also agreed to follow my fiance, to allow my fiance, Jessica, to do the exchanges. Jennifer agreed to the phase plan in an email. Then when it was time to start phase 3 on 2 of 24, they reached out to Barb and the understanding of the phases went from 1 month to 3 months. I've been in phase 2 since 1/19 of 24. That's 23 weeks. There have been no concerns or setbacks to phase 1 or supervised visits. I have been allowed unsupervised visits for 3 hours with my son and open video calls. There have been no frustrations on my part until the 3-month period has passed and I'm still not being allowed to move forward and have my son come to my home. When I had my one-on-one with Barb, she told me that Sarah and her attorney have no intentions of going through with phase 3 since the first time she recommended it. That is why she told us to come to court. I'm representing myself. I cannot afford an attorney to represent me. I'm not 100% on how to file these motions or the court rules, but I have done everything I can. I will continue to do whatever it takes to get my relationship back and more parenting time with my son and my weekends back. I didn't get a chance to respond to Miss Mansauer's letter filed the day before court because Jennifer had emailed me saying that my response was already late. So,
Your Honor, I'm going to object because I never said to him he can't file a reply.
So I would say I feel her opinion is still biased. Miss Mansauer's opinion is still biased. And that is what I said in my previous declarations. And the good reasons I feel that is because Judge Evans ruled reunification to start almost a year ago. It is also one of the things we had to go to court for because we couldn't agree to the language Jennifer and Sarah tried to use in the court order. Jennifer read that the reunification would not start until the reunification therapist and Silas's therapist deemed Silas ready. Judge Evans changed it to say reunification between Silas and Dustin together may commence when the reunification therapist deems appropriate, instead of including Silas's therapist. I have Jennifer's draft she sent showing the differences. I could file it if you need. It was also Miss Mansauer's recommendation at the time that I should complete 52 weeks of domestic violence treatment, the parenting classes, and have a positive recommendation given before the reunification could start. Her recommendation was written on only what Sarah has told her, and Judge Evans, I feel, recognized this in his ruling. Miss Mansauer has had no update that I have completed all of my parenting classes. I have completed 52 weeks of domestic violence treatment. I have filed a positive report from Stacy. She has never seen the reunification plan, and I think Miss Mansauer's letter clarifies that she has no clue where Silas and I are in the reunification process or our past relationships. Only what Sarah has told her and is encouraging her to write. It also shows that Barb and her do not see eye to eye on what is happening, and she has potentially put a halt in our reunification process by not being able to communicate and work with her during these past several months. In her second to last paragraph in her letter, she writes, I have no significant safety concerns regarding, or she has significant safety concerns regarding the child's well-being if he is to have unsupervised visitations with his father, which we've had unsupervised visits for almost a year now. As of 6/14 of 24, when writing her report, she is concerned about unsupervised visits. which just doesn't make sense because we've had unsupervised visits this entire time. So maybe Sarah's not letting her know. We have been, she is clearly not up to date on what's going on. Sarah's not telling her everything that is truly happening. This makes me question what they are having sessions about. Why there's no notes being provided to the court from Ms. Mansauer. I would hope that the court had a chance to read my declaration. I would just like to add that Sarah did go ahead and cancel our last reunification session scheduled for 6/24. Because she wanted to wait for the court hearing today. I have mixed feelings about continuing reunification as well, but it is still part of the court order and we had it scheduled. I think this shows her character and confirms her misuse of the court. She chooses to follow the court order and when to allow things to happen, like moving into another phase, allowing 3 hours instead of 2, or 4 hours instead of 3, or giving me makeup time, or not owing makeup time, allowing Jessica to do the transfers and communication. If Silas should stop reunification or continue, she is not looking for the best interest of Silas and building our relationship back. And she takes the court order into her own hands, as well as uses the court against me. An example of her taking the court into her own hands in September of 2022, when all of this started, Sarah withheld Silas from me and lied to me for 6 weeks, telling me that he was sick and that someone at his school called CPS about the bruising on his neck. And she has no clue what was going on, all while holding on to a protection order, waiting for CPS to start an investigation. After 6 weeks and me telling her I was going to file a contempt because I knew she was lying about who contacted CPS, she filed the protection order. After I texted my son some pictures of his sisters and telling him that I loved him, she filed 20 violations against me. My attorney at the time informed me he has seen this before because it starts a criminal case for me and gives reasons to grant the protection order longer. Once that is granted, it shows crimes of history to modify the family law order. She called CPS and lied to me about what was going on. I have a recording of her, if I could play it today, of her saying that she didn't know what was going on and that Silas was fine. This was 3 days, I believe, before she filed the protection order in 2022.
So in regard to your request, Mr. Williams, I won't be allowing that. It's not admitted into evidence and we don't do recordings in that manner.
Okay.
Anything else, Mr. Williams?
No, that's it right now, for now.
Okay, thank you. Ms. Jocelyn?
Thank you, Your Honor. I will try to be brief. The majority, I don't believe we need to respond to. This is all regarding incidences from 2 years ago. We are here on his motion to modify the parenting plan. What is not before the court is the issue of modifying sole decision-making. When we petitioned to modify the court, we did not mark that as other. So therefore, we just want to clarify that request is not before the court, even though he's asked for that. Talking about months and us wanting months 1 versus 3, it's actually Barbara who had recommended. Again, this was not a court order, and it was actually several months, so it was a clarifying, not us wanting it. Judge Evans was very clear in his ruling. This process of reunification was to be a joint effort between Ms. Mansauer, the child's therapist, and the reunification counselor. And as you can tell by the letter from Ms. Mansauer, she has not been able to get a hold of Barbara, and Barbara is not responding to her. Additionally, Mr. Williams just stated that it was Ms. Mansauer, Dustin's therapist, who recommended he do 52 weeks of DV classes. That's not the case. The person who recommended that was the DV evaluator, Olivia Lovely. In regards to any unsupervised time, I believe that just started, which is still out in a public place. Sarah can speak to when that started, but unsupervised just meant that Barbara wasn't there. Really where we're at, it's been 1.5 years since Dustin choked out the child and my client got a protection order. This is all set forth in the protection order. I don't feel it's necessary to go over, but to mention that, you know, the child did have injuries, had to go to the ER, etc. My client had to get a protection order, and my client just renewed that protection order. The court in Clark County renewed it for an additional 2 years. My client spent a lot of time delineating in her declaration why the request for visitation should be supervised is, but I think it's really important to really look at what Ms. Mansauer has said. And I just wanted to point out some highlights. This This child has been in session with her since he was choked by Mr. Williams. She has seen him for 35 sessions. This is not minimal. She very clearly points out the difference between reunification and individual. He said the collaboration of individual and reunification is quite fundamental, and frankly states that Barbara is not collaborating with her. She's asked for treatment plans for Barbara, and Barbara's response was get it from the mother. When she said it was standard practice and she had assigned ROI, she still didn't get that information. This should be a free flow between the two of them. She states the child has, yes, it's been a long time. We all agree to that. But the issue is the child isn't over being choked and strangled by his father. The child's continued to disclose thoughts and feelings to his counselor, in which the child did not perceive Barbara, who is a reunification counselor, as supportive of him, his well-being, or an ally. And the counselor states this is a significant barrier to reunification and to his mental health treatment. She shared this multiple times with Barbara. However, over the course of the treatment and trying to work with her, basically this alliance between the two was compromised. She's in agreement that, yes, reunification is to facilitate positive outcomes, but believes the reunification in this scenario has actually caused an adverse effect. She states that she believes reunification counseling started before the father was truly ready or willing to listen to the child and understand the disconnect between him and the child was a direct result of him choking the child and his abusive behaviors. She also believes that Dustin's tendency
Your Honor,
to make...
can I object, Your Honor? Miss Mansauer's never talked to me. She's never spoke to me. If you read the police report, there's no choking. There's no...
Your Honor, I'm going to object to this.
Mr. Williams, stop. Ms. Jocelyn.
Thank you, Your Honor. Ms. Mansauer went on to state that the father's tendency to make comments to the child, such as accusing the child of being brainwashed, using physical intimidation tactics, such as getting in his face, demanding him to answer questions, or becoming defensive when the child expresses himself, suggests that Dustin is not truly hearing Silas's perspective, and that Dustin may not be ready to acknowledge his role in this strained relationship. The child has verbalized to her numerous times about Dustin's verbal aggression towards not only Silas, but the reunification counselor herself, the maternal grandparents, and his partner, Jessica, during either supervised visits or therapy sessions. This is what's happening with supervised visits and therapy sessions. He's verbally aggressive to the child, to his partner, and to the reunification counselor. What is he going to do until he gets proper treatment and has further supervised time? The counselor is concerned that Dustin's persistent aggression is basically just bringing in hostility into the space that is supposed to be a safe space and just reinforces the disconnect between him and Silas. And she's concerned that it's going to re-traumatize Silas. He has confirmed to the counselor his discomfort and anxiety around Dustin, yelling to the counselor, and that basically Barbara's response is, well, yelling isn't illegal. There's been ongoing verbal aggressions from Mr. Williams that reinforces the child's feelings of fear and insecurity, which she has gone on to state further damage Silas's physiological and psychological well-being. She's very concerned that the call or the instance about the yelling and Barbara's dismissing it, saying it's not illegal, again, is undermining Silas's sense of safety and trust in Barbara and the process. And that the child can feel unheard and invalidated when experiences such as this are just simply brushed to the side, and it's leading to a breakdown between Barbara and Silas's relationship. She also acknowledged that during a recent session on June 12th with my client, I believe has also acknowledged that there was a one-on-one discussion between Silas and a reunification counselor about his fears going to his father's house. And then what Ms. Mansauer is concerned with is that Barbara's response to him telling her concerns is basically that's not enough to pause unsupervised visits, and that the courts are likely going to order it anyway, and he should just be ready for it. She's highly concerned that she struggles to even find why this was even said in this way. She believes that despite the reunification counseling, the time spent doesn't yet to have seemed to succeed in effectively building the relationship between Silas and his dad. He doesn't feel safe around his dad. He continues to express fears about the father's struggles or inability to regulate his anger with people, especially Silas. This causes him a level of anxiety when Mr. Williams is present. He doesn't have a complete sense of safety, emotionally or physically, with adults, and even more so when he's not in a safe space. He doesn't feel comfortable being in Mr. Williams's home or transported by him. This is directly from his counselor. She also says regarding moving forward to unsupervised, she believes the process of reunification must be completed with no safety concerns. She's concerned that the reunification counselor is allowing Mr. Williams to get so upset in a reunification session that he is physically intimidating Silas by getting in his face, demanding that he answers a question asked by the counselor, in which the child was just simply too scared to answer it. And in therapy, he expressed his fear in that moment. This just happened in June. Her thought process is that if Mr. Williams is truly sorry, then how to show that is changed behavior, which he has not done. She's concerned by many of those incidences. She's concerned that the reunification counselor has witnessed several instances of Dustin being verbally upset and aggressive, sometimes at her, and this raises serious red flags regarding the emotional safety of Silas around the father when he has an anger response. She had to speak to reunification counselor, had to speak to Dustin about his behavior one time during a session, saying if he continued down this path, she would have to cease the session. However, despite all of these concerns, Barbara's like, there's no red flags. So Miss Mansour, who's had quite extensive time, has been with this child since the choking incident, thinks at this point, and my client agrees, that an option might be probably the best option is to appoint a GAL, because a GAL can really listen to the child, provide more of an appropriate and protective approach. The reunification counselor herself has various safety concerns regarding Mr. Williams if he is to have unsupervised time, especially regarding the physical intimidation, verbal aggression, and his unpredictable behavior to the child and others. She indicates it's crucial to prioritize Silas's safety and well-being to ensure that any visitations are made with careful consideration. And then regarding my client, I know Your Honor reads everything, so I'm not going to go through, but she delineated in her declaration several instances of his continued aggression, violence, anger that's not under control. Additionally, the recommendations of the counselor are not a court order. My client agreed to start them. She didn't agree to adopt phase 1, 2, and 3. She agreed to do each of the phases separately. We started phase 1, and then we addressed phase 2. Once it became phase 3, my client said no, based on all of these reasons in the reunification counselor. Even the reunification counselor herself in her letter states that Mr. Williams is clearly frustrated, that Mr. Williams struggles with accepting this progress and does not necessarily even see a need for unification. He needs to practice listening and validating. She indicated the session on May 3, where Mr. Williams was frustrated with the counselor and wanted to talk to the child and wanted to question him, and she had to redirect him. She even indicated the minor has told the counselor he yells a lot at his spouse. She's had to place him on notice that he needs to follow her direction. And even now she recommends that he does not drive or go to his house for at least a month. My client believes, based on everything on Ms. Mansour's letter and even what the recommendation of the reunification counselor, that at this point, a GAL is best to be appointed to really investigate this. And based on the disconnect and Barbara not involving the therapist like she was court ordered to do, that Barbara should be dismissed. Dustin states that he's finished his DV. However, the documentation he submitted states that he's completed 31 of 52 DV sessions. It's been a year and a half since he was supposed to undergo those, and he's only on session 31. He should have finished this 6 months ago. He submits a letter from DV treatment. We just simply object as it's not signed under penalty of perjury. So at this point, it's my client's request that visits are to be 3 hours per week, supervised by either a professional monitor paid by Dustin or a mutually agreeable third party. Barbara is not to supervise. A GAL is to be appointed. Barbara is to be dismissed as the reunification counselor. Thank you, Your Honor.
Mr. Williams, response?
Just wanted to clarify, Silas and I have had unsupervised visits now, almost 7 months, unsupervised visits, with no issues or nothing. And Barbara has monitored and supervised these visits from time to time. She's popped in. So I just
Your
wanted
Honor,
to,
we're gonna object as it is facts not in evidence. It has not been 7 months and there's nothing to that effect in declarations.
Mr. Williams, you need to stick to the declarations, the statements that you've made in writing.
it's in my declaration.
Go ahead, just, I'll give it the weight that it needs.
All right, I wanted to apologize about Miss Mansauer recommending the 52 weeks. I meant to say that she wanted me to complete a 52-week evaluation or classes before I could start reunification. To clarify with the 52-week thing, I submitted my graduation certificate. So Jennifer saying 31 weeks is a lie. Miss Mansauer didn't reach out to me for the plan until just before she wrote this letter, or she didn't reach out to Barbara just before she wrote the letter. And again, her recommendation is just biased because she only has video calls with Silas. These 35 sessions that she's had with Silas have video calls. She's never met me. She's never met Silas physically in person. She's never seen him and I interact together. And Sarah's just sitting off in the other room, kind of behind Silas, I'm sure. Barbara, the reunification.
Again, Your Honor, we're gonna object. It's not in his declaration about her sitting behind, I assume.
All right, let's wrap this up. It's afternoon.
So Barbara has seen Silas and I interact many, many, many times. Miss Mansauer, again, has never spoken to me. She's never called me. She's never emailed me. She's never asked me any questions. She never had a conversation with me. The impersonation tactic that she says is untrue because Miss Mansauer never talked to Barbara about what happened at that session. I filed a police report also on showing what my son felt the incident was the day after it happened. And it was not a choking incident. The police report didn't state any of that. I'm asking for the court to order the phase plan and allow 4 to 6 hour visits, unsupervised and open calls, and work towards just truly reuniting me and my son back together. I've done several classes of stuff that I submitted in my declaration. You'll see it. So my Children in Between class, my Incredible Years class, my 52 weeks of domestic violence treatment, all with good reviews, all with A+ stars from the teachers, all. So it was all positive reports from all of my stuff that I submitted.
All right. So here's where the court is at. First off, in regard to changing the current order or what's in place, that nothing is going to happen there at this time. So basically your request in regard to the plan or parenting plan or however you want to put it is denied, or the order, I should say. However, I am going to appoint Jennifer Schaefer, our court investigator. I look to see, and I'm not seeing what I thought there was somebody already appointed, but apparently not. But Jennifer Schaefer does these matters, and they tend to be shorter matters, and it may be a full guardian item needs to be appointed after that. But at least for now, I want to have Jennifer Schaefer, the court investigator, appointed. And I'll go ahead and do that order, and that way I can get it going. Mr. Williams, is your current contact information up to date with the court?
Yes, ma'am.
Okay. All right. So you'll hear from Ms. Schaefer. So that's who she is. And then she can go ahead and review everything and make recommendations as far as that goes. As to the other request to modify the temporary family law order, that part, I just took what you had proposed and wrote denied through it. That way you don't need another order as far as that part of it goes. but I will do the separate order for the guardian ad litem. So I understand, Mr. Williams, you want things to move forward, and I get that. And we'll just see what Ms. Schaefer has to say as an independent person to look at this and make a recommendation to the court. The other thing you need to understand, Mr. Williams, too, is that these are temporary orders. So there's nothing stopping you from setting it for trial if you want to do that. That's totally up to you. But that is an option as well. But meanwhile, I'll go ahead and get Ms. Schaefer moving. Okay?
Thank you, Your Honor.
All right. All right, that concludes the docket.
Thank you.